Federal marshals just seized Ivanka Trump's passport. Friday morning, 6:47 a.m. 4 U.S. marshals knock on her door in Miami. When they leave, they have her travel documents, her freedom to leave the country, and evidence that could send a former White House advisor to prison. But here's what nobody's talking about. The person who made this possible wasn't a prosecutor, wasn't an FBI agent, wasn't even a political enemy. It was her stepmother, Melania Trump. 2 hours of testimony, under oath, behind closed doors, and what she said changed everything. If you want the full breakdown of what's really happening, hit subscribe right now, because what I'm about to show you isn't making it into the headlines, and this case is moving faster than anyone expected. I just spent my entire weekend going through 187 pages of court filings, 3 times, and what I found goes way beyond what you're seeing on the news. This isn't about politics. This is about $127 million, 23 shell companies, and a pattern so clear that a federal judge looked at it and said, she might run. Let me walk you through exactly what happened. Thursday afternoon, Melania Trump walks into a federal building in Washington, D.C. She's there voluntarily. No subpoena forced her. She chose this. 2 hours later, she walks out. The very next morning, Friday at 6:47 a.m., U.S. Marshals are at Ivanka's door. That's not a coincidence. That's a prosecution strategy. And here's what makes this absolutely unprecedented. Melania testified about her stepdaughter. 147 questions, 1 break. And she never once invoked her Fifth Amendment right to stay silent. Think about that. A stepmother, under oath, answering questions about her husband's daughter in a federal criminal investigation. That doesn't just happen. There's a reason behind it, and the court documents tell us exactly what that reason is. Here's what prosecutors say they found. I'm pulling this directly from the filings, page by page. Page 43. The defendant facilitated the movement of funds from Trump Organization's subsidiary accounts to a Delaware-registered entity with no identifiable legitimate business purpose. That's not my opinion. That's what the legal filing states. Money moved, and where it ended up makes no sense based on the paperwork. But page 89 is where it gets serious. Between March 2023 and November 2024, Ivanka Trump's signature appears on 31 wire transfer approvals. 31. The total? $84.7 million. Where did it go? A holding company in Cyprus, a subsidiary in the Cayman Islands, and a Nevada-registered company with 0 employees, 0 revenue, and no physical office, all documented on pages 91 through 103. Now, here's the part that almost nobody is reporting, and it's buried in Exhibit F on page 147. Over a 14-month period, Ivanka personally withdrew $3.2 million in cash equivalents. But here's the thing. She never took out more than $9,500 at a time. Not once. Read that again. Always $9,500. Why does that number matter? Because federal law requires banks to automatically report any transaction of $10,000 or more. If you stay under that threshold, no automatic report gets filed. The legal term for this is structuring, breaking up transactions deliberately to avoid federal reporting requirements. And prosecutors are arguing this proves intent. Here's where it all connects. According to the official transcript, Melania told investigators she was present during multiple conversations where Ivanka discussed keeping transactions below the reporting threshold. Page 156, paragraph 14. There's a direct quote. The witness, identified as MT, Melania Trump, said Ivanka told people to keep it under 10, always under 10. Not $9,000, not $8,000. Always just under the federal limit. And prosecutors aren't just saying Ivanka did this. They're saying she knew exactly what she was doing. Page 162. They argue she had specialized knowledge about federal reporting requirements because of the position she held in the White House. So, let's add it up. 31 wire transfers totaling $84.7 million. 3 offshore shell companies with no actual operations. 89 cash withdrawals, all under the reporting threshold. Direct witness testimony from a family member, and a pattern that stretches across 20 months. Legal experts are calling this one of the most thoroughly documented
I
money
need to be
laundering
fair
cases
here, because
involving
the
a
defense
former
does
White
have
House
real
official in
arguments.
recent memory. First, the timing is suspicious. This investigation ramped up aggressively right before election season. That could be coincidence. It might not be. Second, using Melania's testimony against Ivanka raises serious questions about family dynamics. Did prosecutors pressure one family member to turn against another? Third, structuring charges aren't as simple as they sound. Withdrawing cash under $10,000 isn't automatically illegal. Prosecutors have to prove you did it specifically to avoid reporting requirements. Pattern alone doesn't prove intent. Harvard law professor Alan Dershowitz said it clearly. Structuring charges require proof of intent to avoid reporting. Patterns by themselves don't convict. And he's right. The defense filed 47 pages of business records showing the offshore companies had legitimate purposes: international licensing deals, brand management contracts, and documented revenue streams. Their argument? The money moved because the business moved. Nothing sinister. They also directly attacked Melania's credibility. On page 23 of their motion, they wrote that the witness identified as MT has significant personal and financial motivations to provide testimony favorable to the prosecution. Translation: Melania might have her own reasons for cooperating that have nothing to do with truth. Constitutional law professor Jonathan Turley weighed in, too. This case raises serious questions about using family testimony and the timing of these charges. So here's where we are. The prosecution says this is textbook money laundering, wire transfers, shell companies, structured withdrawals. The defense says this is sloppy bookkeeping, family business complexity, and political targeting. Both interpretations are possible. That's what makes this complicated. Let me walk you through the timeline, because the details matter. 6:47 a.m. Eastern, Friday, February 6th. 4 U.S. marshals arrive at Ivanka Trump's home on Star Island, Miami. They present a court order. They demand her passport. Her lawyer is on the phone within minutes, calling the duty judge, requesting an emergency order to block the seizure. 8:12 a.m. Request denied. The court's reasoning? Ivanka is a flight risk. She has international business connections. She has access to private planes. There's enough evidence to believe she might leave the country. 7:23 a.m. Passport surrendered. By Friday evening, $15 million bail posted, GPS monitoring device attached, travel restricted to the Southern District of New York. All of that happened in under 12 hours. But while everyone was focused on the passport story, something else happened that most people missed. The court unsealed Exhibit G. 67 pages of communications, emails, text messages, voice message transcripts. Then the judge did something extraordinary. She ordered Ivanka's legal team to surrender all electronic devices used for business communications since 2021. Laptops, phones, cloud storage access, everything. Deadline: Wednesday, February 11th. That's this week. Former U.S. Attorney Barbara McQuaid called this move extraordinary. She said, "This wasn't reactive, this was planned." Look at the sequence. Thursday, Melania testifies. Friday morning, marshals arrive. Friday afternoon, sealed exhibits made public. Friday evening, device surrender ordered. That's not scrambling. That's executing a strategy. And here's what it means. Prosecutors think there's more evidence to find. They already have what Melania told them. Now they want to check it against Ivanka's own communications. They're looking for deleted messages, encrypted app conversations, anything that confirms or contradicts Melania's testimony. The devices will tell the real story. You might be thinking, this is just another rich person's legal problem. Why should I care? Here's why. If you own stock in any business connected to the Trump name, pay attention. Trump media stock dropped 12% on Friday. Trump Organization bond prices fell 8% by market close. Your investment portfolio might be affected through index funds, real estate trusts, or banking sector holdings without you even realizing it. But there's a bigger reason this matters. This case is setting a legal precedent. In the future, if you're ever involved in a business dispute or legal matter, the rules about family testimony will apply to you. Right now, under current law, prosecutors can approach your spouse, your adult children, Anyone who knows about your finances, offer them immunity and ask them to testify. This case proves they're willing to do exactly that. Spousal privilege exists. Married couples generally can't be forced to testify against each other. But Melania wasn't forced. She volunteered. And when it comes to stepchildren, there's zero privilege protection. According to the filings, investigators have identified 23 people who received money from the shell company network. Some have already hired lawyers. Others are reportedly cooperating. And here's the uncomfortable truth nobody wants to say out loud. If you've ever broken up financial transactions to avoid reporting requirements, you're watching your own methods being prosecuted right now. Small business owners, real estate investors, anyone who handles significant cash. The government is using this case to send a message, not just about the Trump family, but about anyone who treats transaction reporting limits as optional. If you've ever deliberately kept cash withdrawals under $10,000, you're part of this conversation whether you want to be or not. I'm not trying to scare you. I'm telling you what the legal landscape looks like. The IRS has increased enforcement of structuring violations by 340% since 2020. This is the most high-profile example, but it's far from the only one. Here's what's coming. Wednesday, February 11th. Federal Court Status Conference. Ivanka's team will argue for changes to travel restrictions. Prosecutors are preparing additional exhibits. Thursday, February 12th. The grand jury meets again. Additional charges are still possible. Friday, February 13th. Electronic devices must be surrendered. This is the deadline that matters most. Whatever is on those laptops and phones becomes evidence. If messages were deleted, forensic experts will recover them. If encrypted apps were used, prosecutors will know. If the communications match Melania's testimony, the case gets stronger. If they contradict it, the defense gets ammunition. Friday is the turning point. On the surface, this is about a former White House advisor facing federal charges, but the real story is Melania's role, why she cooperated, what she actually said, and whether her testimony holds up. Right now, Ivanka Trump can't travel internationally, can't speak publicly about the case without violating the gag order, can't leave the Southern District of New York without court permission. She went from running international businesses last month to having her movements tracked by GPS this week. And the situation isn't calming down, it's intensifying. The defense filed 3 emergency motions over the weekend, all challenging different aspects of the prosecution's actions. The judge's response is expected Wednesday. Here's what we know for certain. The evidence is substantial. Melania's testimony is unprecedented. Both sides are fighting aggressively. What we don't know is whether any of this ends in conviction. High-profile cases have collapsed before. Political pressure, aggressive prosecution that couldn't finish, weak evidence that looked strong on paper. This case might be different. The documentation is unusually detailed. The witness is unlike anything we've seen. But we're still in the early chapters. Legal experts agree on one thing. The volume of evidence at this stage is unusual. The passport seizure signals high confidence. The device surrender suggests they expect to find more. Former DOJ official Harry Litman put it simply. Flight risk determinations require probable cause. The judge saw enough. Courts don't guess. They assess evidence. If any of this is relevant to your life, your investments, your business, your financial transactions, here's what informed people are doing. Reviewing transaction records with accountants, making sure there's documentation for any significant cash movements, asking financial advisors whether they might be at risk, not out of paranoia, out of awareness. Whatever happens to Ivanka Trump will influence how prosecutors handle high-profile financial cases everywhere. If they win here, they'll get more aggressive. If they lose, defense lawyers will have a blueprint. Either way, the rules are being written right now. The story is still developing. The devices haven't been turned over yet. The grand jury hasn't finished. The trial hasn't been scheduled. But Friday is 4 days away, and everything could change. I'll be covering every update as it happens. If you want the full breakdown the moment those devices are examined, the second the grand jury makes a decision, or when any new evidence drops, subscribe now. Because this is moving fast, and the mainstream media is only giving you pieces. Drop a comment and let me know. Do you think Melania's testimony will hold up under scrutiny? Or is this case going to fall apart? Let's talk about it. The clock is ticking, and the truth is coming, one way or another.